Right. Welcome back. Welcome back. This is Cognitive Capacity. This is season 302. So in episode 1, I told you all that I was going to go backwards and start with the basis, and that is requiring me to unpack some of the hallmark Supreme Court cases that made juvenile justice law what it is today. So in part 1, I mentioned that I would be talking about the In Re Gault case. And so this is what episode 2 is about. Episode 2 is about the Supreme Court hallmark case In Re Gault about a juvenile whose name is Gerald Gault. And so let's just jump right in. Okay, so Gerald Gault, Gault, is a part of a landmark Supreme Court case that held that due process 14th Amendment applies to juvenile justice law. And I'm going to unpack all of that, so just rock with me as we dig in. Gerald Francis Gault was 15 years old. He was a white male who lived in Arizona at the time of the charges. And so what happened was, ultimately, he was arrested for making allegedly obscene phone calls with his friend to a neighbor named Miss Cook. And Miss Cook was receiving these obscene prank phone calls from Gerald and his friend Ronald. And at some point, Miss Cook got tired of the phone calls, and on June 6, 1964, she filed a complaint with the police department. And secondary to that complaint, on Monday, June 8th, 1964, 2 days later, at 10 a.m., the police came to Gerald Gault's house and arrested him. And they also went to Ronald's house and arrested him. Now, what I want you to remember in this process is that when they arrested Gerald and Ronald, remember I told you that Gerald is 15, Ronald is about the same age, they did not notify Gerald's parents. And so all of this is happening in Gila City, Arizona at the time. And when they arrest Gerald, the research shows that he was already on 6 months probation for being with a kid who apparently stole a wallet from a woman's purse, and it was classified as a minor theft. He was not the person who stole the wallet, but because he was with the child who did steal the wallet, juvenile court gave Gerald 6 months probation. So because he was on this 6-month probation, and now he's getting called for these obscene calls, it appears like this is, like I said, Gila City, Arizona, small town. The law enforcement knows him. And so they take him from his home, don't let his parents know, and they arrest him and place him in a holding cell. So they get Gerald and his homie and they take them to the children's detention home in Arizona. While they're at the children's detention home, they are questioned. This is where it starts to get muddy, because there's no documentation that they were ever Mirandized when they were arrested. And so, in addition to Gerald's parents not being notified, Gerald is then at this children's detention home being questioned by the law enforcement. And so, he's here, and when the cops come to arrest Gerald, his parents, like I said, were at work, so they were not notified. When his parents came home around 6 p.m., the day they arrested Gerald, they're looking for him. His mother specifically is looking for him. And his mom is thinking like, oh, he's somewhere outside in the neighborhood playing. So she sends the older brother to look for Gerald. And he goes out to look for him. He eventually comes back with information from Ronald Lewis's family that the two boys have been arrested. Now, why, if Ronald Lewis's parents knew that they were arrested, they didn't notify Gerald Gault's parents? I have no idea. And I'm not sure why at the time this is happening they weren't more alarmed. It's beyond me. But, it's lost on me how you chilling and you're waiting until somebody is actually looking for their child to then tell them that they were arrested. Craziness for me. So anyway, his older brother comes back to the house, tells his mommy that Ronald Lewis's parents told them that both of them have been arrested, Gerald and Ronald. So Gerald's mother goes to the police station to find out, what's up? Like, what happened? Why you have my child? Why is he here? What's going on? So they're down there and another tricky thing starts to happen. And ultimately what happens is, remember I told you, they started questioning him. So Gerald, while they were questioning him, mentions that he did not make the calls and that he just dialed the number and gave the phone to Ronald. And so when his parents get down there, the detention supervisor ultimately says, we're going to hold him. We're not releasing him. The day after he's arrested, he was arrested again, remember, on June 8th. So June 9th, he's scheduled for an initial hearing, so for them to come back. So they keep him there for a few days until the initial hearing is supposed to happen. Okay, so before we get into that, I want to just kind of make it clear that when I say that they were talking about these obscene phone calls, apparently it was characterized as dirty talk. Now, how the dirty talk rose to the level of Gerald and this boy being arrested and held in a detention center and needed an initial hearing is, again, beyond me. My theory is because Gerald was already known as having interaction with the law in juvenile since he was on 6 months probation. They kind of just have no tolerance, because this could have been a stern talking to versus taking him to jail for dirty talk. They're 15. I remember when I was a kid, I probably made a few prank calls. Again, though, we have to keep in mind this is 1964. This is the time when married couples still slept in separate beds most of the time. And, at least TV-wise, they would put married couples in separate beds because it was kind of considered inappropriate to show that they slept in the same bed. So this is a time when things were very conservative. This process, is ultimately a weird one. And so they decide to give him an initial hearing. There ends up being 3 hearings. 3 hearings initially in total held without witnesses being sworn in and no reports about the situation, and no reports, including no petition or probation report, being provided to the kids or their parents during this process. So the mother knows nothing about what's happening besides what the probation officer told her when she came. We brought him in because he and another boy made obscene calls. We're going to hold him and he'll have an initial hearing the next day. The woman who filed the complaint, Miss Cook, never even appeared to identify that these were in fact the 2 boys who made the prank calls to her. And so, this is, again, like I said, just very weird work going on here. Like, everything is just kind of being done out of whack for certain things. But, unpacking that is a bit complicated because there's so many different moving parts to the situation. But I want us to stick right now on the fact that we have a child that has been arrested and his parents weren't notified. We have a child that has been arrested and he was not Mirandized and was questioned. We also have a child who is facing an initial hearing whose parents have not received any reports about the situation, and the person who filed the complaint has not been present to either identify, confirm, or deny. And even though, it may sound like, oh, what's the big deal? Even his mother at that time knew it was weird that the person who, Miss Cook, the neighbor, who filed this complaint, wasn't present. She adamantly requested, Gerald's mother adamantly requested that Miss Cook be there to identify which of the 2 boys had actually done the so-called dirty talk on the phone. And so, we're now getting into the conversation of the procedural issues. And so for my law students and law hopefuls, listening, this is a case ultimately about procedural posture and due process. And if you've started law school, if you have not, just a few background information. Due process falls under the Due Process Clause, which is in the 14th Amendment. So whenever you see or read or hear about a case where there is a question or a challenge to the procedure or process of a situation or a case, it will likely fall under the 14th Amendment Due Process Clause. So keep that part in mind, that we're talking about procedural issues that then qualify under Due Process Clause, which falls under the 14th Amendment. So ultimately, because of the way things were done, like I said, arrested him, did not notify his parents, arrested him, did not Mirandize him, questioned him. He had 3 trials in total, and the person who filed the complaint was not present. So right now we are talking about some major concerns, to the point that after, he is charged, his counsel files an appeal challenging the constitutionality of the Arizona juvenile code and the procedure used in this case on the ground of denial of various procedural due process rights. His lawyers are arguing that Gerald's due process rights were violated under the 14th Amendment. And so I want to unpack the different hearings so that we can kind of get a full understanding of what was exactly violated and how it was violated under the 14th Amendment. So to tap into our legal hat again, in adult courts, a defendant has the right to confront the witness or, the witnesses or the person who filed the complaint against them. This falls under the 6th Amendment, which is known as the Confrontation Clause. So the Confrontation Clause says that if you are accused of something, you have the right to confront your accuser in court. And so what we're seeing here is that in the 60s, youth and their families were not automatically being given this constitutional right to confront their accusers or witnesses. And so it's important to talk about that because the Confrontation Clause was established from another hallmark Supreme Court case that we may talk about in another episode. So it was something that was expected to be done because it existed already. It wasn't something that was created from this case. The right to confront your accusers and witnesses that are speaking against you was already established in the law, and it was expected that anybody who is facing a trial has that right. So you would imagine that at the end of the 3 hearings, in each of the 3 hearings that Gerald had, the person who filed the complaint, which was the neighbor, Miss Cook, would be present because she filed the complaint and he has that right to confront her. But at the end of the 3rd hearing, this still had not happened. And so what ended up happening was it was a he say, she say, the report from the detention supervisor, the probation officer, the judge, and then Gerald's word. And from that, the end of that 3rd hearing, Gerald Gault was sentenced to 6 years at the state industrial school until he reached the age of 21 for a crime that, if he was actually already an adult, would have only been a maximum sentence of 2 months in jail and a $50 fine. So the variation in how harsh they are charging him for a crime that's technically a slap on the wrist for an adult is obscene. It's wild. So here's another procedural issue. At the time, in the 60s, Arizona law did not permit appeals in juvenile cases. So once they sentenced Gerald to 6 years at the state industrial school until he reached the age of 21, there was no procedure for his family or his attorney to appeal that sentence. So his family had to go directly to the final step and file what is known as a writ of habeas corpus. And so they filed this writ of habeas corpus in Arizona Supreme Court because, again, there's no appeal process. So let's chat about what a writ of habeas corpus is real quick. A writ of habeas corpus is a legal procedure that is made to a court when a person wants to challenge the legality of confining someone. So in Latin, writ of habeas corpus means to have the body of. So what it ultimately is a motion ordering the person or entities, in this situation, the court and the state industrial school, who has detained another person, which would be Gerald, to produce the body of Gerald, and causing the court to examine the cause and the legality of detaining Gerald. And so ultimately the writ of habeas corpus is alleging that the imprisonment and detention of the person is unlawful. Okay, so once they filed this writ of habeas corpus, the case goes first to Arizona Supreme Court. When it got to Arizona Supreme Court, they held that, yes, juvenile court proceedings require the due process, but Arizona Juvenile Code and the proceedings in Gerald Gault's case did not violate that due process, which, like I told you, there was many violations. He didn't get a chance to confront Miss Cook. They did not tell his parents what he was being charged with. There was no report. They didn't know how to prepare or defend him. They didn't Mirandize him, and they took testimony from him and used it against him in court. So many things. So when they said, no, there was nothing done wrong, the sentence stays, the parents, then have to fight a different way. And this is because the Arizona Supreme Court was arguing that at the time the juvenile code in Arizona, because they didn't have appeals, it was to be read impliedly implementing the due process concept. So ultimately they were saying, it's implied and we didn't violate any part of it. But the family was not satisfied with the Arizona court decision to dismiss their writ of habeas corpus. So they then appealed that decision. And so when they appealed that decision, they broke down specifically what they were arguing for. So the first thing they were arguing for was that the waiver hearing did not measure up to the components of a due process and fair hearing, which is what we talked about in episode 1 in the Kent v. United States case around due process and fair hearing. The second thing they argued was that the family did not get adequate written notice of the specific issues they must meet. And when they were told finally what was going on, it wasn't provided in enough time for them to prepare a defense for the hearings that Gerald ended up having. And remember, I told you he had 3 hearings. The third thing they were arguing was that they were not informed of the right to counsel, and that if they weren't able to afford counsel, one would be appointed to them. And specifically in the habeas corpus, Ms. Gault's report said that she did tell them that she knew that she could employ one, but that does not rise to intentionally relinquishing or abolishing a fully known right. So ultimately, what the argument is that just because she may have been aware that she could get her own lawyer does not relieve the legal system of adequately notifying them of what their rights are. The fourth thing that they were arguing was that apparently, as we discussed, both boys talked, and they both talked to the cops and they pointed blame at the other. And there, like I said, there was no evidence that they were Mirandized. And because of this violates the constitutional privilege against self-incrimination. And ultimately, what the constitutional privilege against self-incrimination says is that an admission by a juvenile can't be used against him in absence of a clear and unequivocal evidence that the admission was made with awareness he did not have to speak and would not be penalized for remaining silent. And so, again, because these are juveniles, there's specific things that have to be in place when you are Mirandizing them. And we're going to unpack Mirandizing and cognitive capacity in a second. But because there's no evidence that Gerald was ever Mirandized, that also means that there's no evidence that he had a clear and unequivocal understanding that the admission was made with awareness that he did not have to speak, and that if he chose not to speak, he wouldn't be penalized, which is you have the right to remain silent. And anything said against you anything said could be used against you in a court of law. Because they did not have proof that they gave that to him, apparently Gerald Gault's admission did not rise to being a voluntary confession, because we don't know if he fully understood what he was doing when he was speaking to the cops without counsel and without knowing his rights. And then the fifth thing that they argued was that, as we discussed, Gerald wasn't afforded the right to confront and have sworn testimony from the witnesses about him and made them available for cross-examination. That would be Miss Cook. So because Miss Cook was not present for any of his 3 trials, he wasn't afforded his right to confront them and have them testify, Miss Cook testify under sworn testimony. So those are the 5 things that they bring to their next appeal when they argue the dismissal of their writ of habeas corpus from the Arizona Supreme Court. When Gerald was taken to the detention center, the detention supervisor that I kept mentioning, his name is Officer Flagg. And again, I told you this gets very messy. So apparently, Officer Flagg was both the deputy probation officer and the superintendent of the detention home. So he worked in both capacities. So remember I told you Gerald was already on 6-month probation. Officer Flagg is the deputy probation officer. So he knows about Gerald's 6-month probation from a whole nother situation where Gerald was not the actual person who committed the act. He was just with the person. And now he's present for this situation where, again, nobody actually knows if Gerald actually made the prank obscene calls or if he was just the person whose phone got used. But this officer is weaved in between this and both sides. There is no level of neutrality or respect for the fact that this is a big conflict of interest. And so because Officer Flagg is the superintendent of the detention center, he was supposed to file the petition to the court. From the records, it is revealed that he filed a petition with the court, but he filed it on the day of the hearing. And this was never served to the Gault's family. So even though the mummy went up there the same day that they arrested him, and remember they had a hearing the day after he got arrested and all of this stuff, and then he had 2 other hearings after that. The Officer Flagg didn't file the report until the day of the hearing. So the parents didn't even get a chance to see the report and again prepare. So they actually never even saw the petition until 2 months later during the process of this habeas corpus that they're filing. And so his trials happened in June. They didn't see the report until August 17th, 1964. So they never had a chance to prepare for any of the 3 cases. And to make matters worse, when they did get the report, the petition had no reference to the factual basis for the judicial action it took. So what that means is that there was nothing in the report that justified why they decided and had the right to detain him for the amount of time that they were detaining him for, number one, which was the 6 years. It also didn't justify why they detained him during the time of his trial and what were the reasons for even taking the decision for a matter like a phone call being something that needs to go to court. Just craziness. So they get this petition later. And so I want to go back into the 3 different hearings that he had because there's some details that comes out from the habeas corpus about the petition. So again, like we said, as we discussed with the fact that the habeas corpus argued that both boys talked and pointed blame at the other one with no evidence that they were ever Mirandized. This came out from the hearing that happened on June 9th. So on June 9th, during the hearing, Gerald, his mother, and his older brother were present. The father apparently was away on work, and Miss Cook, the complainant, was not there, like I told you. And so no one was sworn in. No transcripts or recordings of the hearing was made, and no memo or record of the proceedings was ever prepared for the June 9th hearing. All of the info about the hearing and the hearing itself came entirely from the juvenile court judge's testimony during the hearing for the habeas corpus, which is sad because they weren't keeping records. They was just doing things fly by night. So when they get Gerald to the stand on June 9th, during this trial, this is the first trial. This is the initial trial, remember, because he was arrested on June 8th. So June 9th, he has his initial hearing. During this initial hearing, Gerald told the judge that he had only dialed the number and then he handed the phone to Ronald, which was his friend. Now, Officer Flagg, remember, that's the one with the conflict of interest, said that Gerald admitted to him during his interrogation of Gerald that he did make one of the lewd statements to Miss Cook. But again, we can't verify that because the interrogation was not recorded. Officer Flagg never wrote a report, and Miss Cook is not present to say who she heard or identify who was who. So now we have 2 conflicting statements. Gerald said he didn't make any of the statements, and Officer Flagg said Gerald admitted to making a statement. And Miss Cook is not there to confirm or deny on either side. So the judge heard this information from Gerald and then heard information from Officer Flagg and said, okay, I'll think about it. That was the end of the initial hearing. There was nothing decided. There was nothing done. Gerald's mother later receives a written note on a plain piece of paper written with a pen from Officer Flagg informing them that a full hearing was going to be set for June 15, 1964 at 11 a.m. Now remember, at this time, they still don't have the petition of what he's being charged with, so they can't even prepare for this hearing that's getting ready to happen on June 15, 6 days later. So about almost a week later, they got to go back for another hearing, and they still can't defend because Officer Flagg has never filed a proper petition and served the family with it. So on June 15, they have the second hearing. And this time, Gerald, his father, his mother, Ronald Lewis, and his father, Officer Flagg, and another officer now, Officer Henderson, are present before the judge. Again, Miss Cook is not present. And this is the person who filed the report. So Gerald maintains in this hearing the same thing he said in the initial hearing. He did not make the call. He just dialed the number and then gave the phone to Ronald. During this hearing, Ms. Gault asked on record that Ms. Cook be present, and her words, and I quote, was, so she could see which boy that done the talking, the dirty talking over the phone. And child, listen, Ms. Gault asked for Ms. Cook to be present, which makes sense and is valid. And the judge said she don't have to be present at the hearing. What? So the person, your key star witness that's holding your whole case together, that can identify, that can deny, that can say possibly who said it, all of that. The person who filed the complaint, let's just start there, does not have to be present, is what the judge said. So apparently, on top of her not having to be present, the judge never spoke to Miss Cook or communicated with her at any time. He never took the time to personally reach out to Miss Cook or ask her to come in to talk to him even. He don't even know what this lady look like. He don't know what this lady sound like. He don't even know if she actually exists. Officer Flagg could have made this whole thing up and nobody actually knows because Miss Cook never materialized. So apparently the only person who actually spoke to Miss Cook was Officer Flagg. And get this, he said he only spoke to her once over the phone on June 9th. So the only time he spoke to her was the day of the initial hearing when the judge said, I'll think about it. Officer Flagg was the only person who spoke to her, and that was on the day of the initial hearing. And that's on the day he writes on a piece of scratch paper that they're going to have a full hearing on June 15th, 6 days later, which is this hearing we're talking about. So at the end of this June 15th hearing, this is where the judge sentenced Gerald to the state industrial school until he was 21 and classified him as a juvenile delinquent. Again, for the charge of lewd prank calls that were never confirmed or denied. So when the hearing for the habeas corpus ends up happening from these trials, the first one again happens at the level of the Superior Arizona Court, and it happens on August 17th. All of these things with the pre-trials has happened. Gerald is sentenced to 6 years. He is sitting in the state industrial school. He's expected to be there until the age of 21. And his parents are like, absolutely not. And again, remember, because Arizona did not have the right for juveniles to appeal sentences at that time, they had to do this writ of habeas corpus. So the writ of habeas corpus reaches the Superior Arizona Court. And on August 17th, Judge McGee, which is the judge that sentenced Gerald to the 6 years, is called to be deposed. And deposed is like testifying, but it's not always in front of a jury or a large trial. And during this time, he's vigorously cross-examined about his actions. And so the Supreme Court, is asking him about his decisions. Like, what led you to sentence this boy to 6 years in juvenile detention and as a juvenile delinquent for prank calls? Like, nobody got hurt. You might have been a little offended that he says something, I don't know, about your boobs or your butt, but 6 years? And so he states, Judge McGee states that he took into account Gerald Gault being on probation. And when he says that, they then challenge him and they ask Judge McGee, under what section of the code did he find the boy delinquent? And these are his words verbatim. He says, I think it amounts to disturbing the peace. I can't give you the section, but I can tell you the law. And so he's supposed to be a judge, number one. This is a judge that made a decision to sentence a child to 6 years in a juvenile detention facility for a prank call, and he can't tell you what section of the code he pulled his decision from to consider Gerald to be delinquent enough to be sentenced to 6 years. And so he then quotes section 8-201 subsection D. And what that says is that code reads habitually involved in immoral matters. But what the judge quoted applies to an adult. It doesn't apply to kids. So then they ask him what habitual matters he was talking about. Says that he gave a vague situation that happened 2 years earlier, like July 2nd, 1962, where a referral was made about Gerald apparently stealing a baseball glove from another boy, and he allegedly lied to the cops about stealing the baseball glove. Now, mind you, I said this was a referral, which means that there were no charges, and it was just somebody saying like, oh, so-and-so stole my baseball. Cop questioned him. He said he didn't have it. They went about their business. So there was no hearing and no accusation because, and I quote, there was a lack of material foundation to charge Gerald with anything. So to say that he used this vague situation to decide that Gerald was a delinquent doesn't match what the subsection reads. And again, the subsection that he is citing his reasons from is that the child was habitually involved in immoral matters. And habitually means you got to do it more than once. A vague referral to somebody told us he stole a baseball glove, we questioned him, but there wasn't enough evidence to charge him, does not rise to the occasion of being a habitual person that is involved in immoral acts. So, they're like, so you had a lack of material foundation and you couldn't charge him with it, but you still made it a relevant factor in deciding to sentence him to 6 years. And, then he says like, but Gerald also admitted to making other nuisance calls in the past. And when they asked him like, what do you mean he admitted to making other nuisance calls, he's like, like he made silly calls or funny calls or something like that. So again, we got 2 instances. Neither one of them were actually instances where he was charged and committed. The only other time he's had involvement with the system is when he is with another friend who committed a crime and he was sentenced to probation. There are no other acts. So to use, the child's statement of, yeah, I've made silly calls before and consider that to be immoral acts and habitually involved in immoral acts is not a strong enough justification to sentence somebody to 6 years, let alone a child. Especially because remember, I do want to bring this back up. Remember that this type of charge of making a crank call at that time, if Gerald was an adult, would have only gotten him up to a $5 to $50 fine and possibly 2 months imprisonment. Nowhere near 6 years. So the Supreme Court heard what he said. The Arizona Supreme Court heard what he said, and the habeas corpus was again dismissed. They said, we don't see any violations, and so, this has no standing. They dismiss it again. But Gerald's parents are not giving up. So the case makes it to the United States Supreme Court on 15th, 1967. I don't know how much you all know about cases getting to the United States Supreme Court, but the United States Supreme Court hears about 1% of the cases that are sent to them. And so it is a very rare occasion where you send a case to the Supreme Court and they'll hear it. Again, remember that appeals and things that go to the Supreme Court is that the court is only reading what already exists in the documents. They are not retrying cases. They are not allowing people to put on new evidence. Whatever is in that packet is what is being heard. And so when it gets to the Supreme Court, United States Supreme Court on May 15th, 1967, in an 8-1 decision, the Supreme Court rules in favor of Gerald Gault. And the decision was written by Justice Fontas. And what they say is that juveniles must have the same due process rights as adults, including rights to call witnesses, have legal counsel, etc. And so that's how things are supposed to be done. That is how Gerald's case was supposed to be done. It also argued that that the law and the juvenile rights are expected to be afforded to all juveniles, and that Gerald's commitment to the state industrial school was a violation of the 16th Amendment, since he had been denied those rights to an attorney, notification of his charges, rights against self-incrimination, and an opportunity to confront his accusers. So, this case, Gerald Gault's case, helped guarantee legal counsel, notification of charges, rights against self-incrimination, and the opportunity to confront their witnesses for all youth and all juvenile courts. And it actually changed juvenile law. Although it's not always well sourced, youth are now guaranteed to all of these rights under the due process law in the 14th Amendment. So let's unpack the cognitive capacity and the importance of the In Re Gault case in due process for youth. So 1, we talked about, the the Supreme Court, United States Supreme Court, deciding that all youth have a right to legal counsel. And so representation is important for youth in many facets, but especially because youth's cognitive abilities, whether there's a disability or not, is very vulnerable to self-incrimination, especially because comprehension functions differently in youth at certain ages. And so we already know, we have a lot of research around Miranda rights and cognitive capacity and comprehension for youth. In addition to that process, investigations and interrogations of youth are very dangerous. And because of the different cognitive capacity of youth, without representation to protect against self-incrimination, youth are very vulnerable to the coercions of interrogations for various reasons. But there is, a large percentage of forced and coerced confessions because youth cognitive capacity doesn't always allow them the ability to understand the techniques and tactics that law enforcement may use during interrogation. It doesn't always allow them because of the developmental process. The frontal lobe houses your problem solving skills and your inferencing skills and just thinking overall in its total capacity. And most times you have to be savvy in inferring where the interrogation questions may be leading you in order to not self-incriminate, which, like we said, the Supreme Court ruled juveniles have the right against self-incriminating. So legal counsel and representation, even, let's just step back a bit, even to the part of notifying his parents when they arrested him so that his parents could have even been present, is important to protect youth against that vulnerability, to protect them from being properly Mirandized and knowing their rights and knowing that they have a right to be silent and not be penalized for being silent, and knowing that they have a right to ask for counsel, an attorney, and they don't have to answer questions until or at all if they decide to. So representation is an important part that the In Re Gault case, solidified and confirmed for youth. It can no longer be argued, oh, it's implied. It is explicitly stated now that they have a right to representation. The second thing is, making appropriate recommendations for placement based on developmental and brain development is another key thing that came out of the In Re Gault case, because, like we said, when the Judge McGee was questioned, his reasoning for sentencing Gerald Gault to 6 years in a juvenile detention space until the age of 21 for something as minute and simple as a prank call, which half of us have done and some of us still do, was not appropriate. It wasn't an appropriate recommendation to place him there for 6 years. It also didn't take into account his age and his physical developmental, and brain developmental process. So In Re Gault case protects youth from harsh penalties. It allows appropriate recommendations, like, for instance, wraparound services, and recognizing that some of these things are youthful actions. Making a prank call and making silly phone calls, like allegedly Gerald admitted to, are youthful actions. These are not things that rise to the occasion of such a punitive sentence of 6 years in confinement. The next thing that, comes out of this cognitive capacity standpoint is procedural fairness. Even just having the capacity or competency to stand trial is important. One, Gerald was not able to confront Miss Cook, which did not allow them proper cross-examination or to be able to prepare for proper cross-examination. But in addition, not taking into account the fact that this is a 15-year-old that you've interrogated without his parents or legal counsel present. You've taken a report and now you're using that report against him in court. And him now having to stand in front of this judge and repeat certain things without fully understanding, what he's being charged with, how to prepare for this, and what way to communicate and speak about things that, in his mind, developmentally, are things that are just child play. Like, if we think about it, most of us, even if we've done prank calls, would never think that a prank call would be something so illegal that we could be sentenced to 6 years. And so I'm pretty sure that Gerald and Ronald didn't see it as being something that would be so severe as it was. And that some of that is a part of the maturity cognitively and developmentally that he is experiencing. And so this is a case of cognitive capacity and just typical neurotypical development, and how without the In Re Gault case, some of these things would significantly impact youth today still if they weren't able to have the right to an attorney, be notified of their charges, be protected against self-incrimination, and the opportunity to confront their accusers. It would just be a free fall of questioning youth and being remiss in telling youth what they're being charged with, and using very minute things that never even entered the court against them to make very harsh decisions. So, we honor In Re Gault case at its anniversary consistently because it is a significant hallmark case that did change juvenile law. And it actually just celebrated its 50th anniversary a few years ago, about 2-3 years ago. And so, it is a major important case. But that is the In Re Gault case with Gerald Gault. The next episode that we're going to do is going to be another hallmark case in that vessel of talking about the right against self-incrimination. I want to tap into another case that is in that same vessel, and it is the Haley v. Ohio case. It happens in 1948, and it's going to talk about coerced confessions and the admissibility of a confession by a 15-year-old in a state criminal court. So that's going to be our next episode. Yeah, I'm really excited to be unpacking these hallmark cases with you all and tapping into both the legal side of things and also the cognitive capacity side of things. Let me know what you think about it. In the interim, check me out on Instagram, Dr. Juvenile Forensic _SLP. And I will see you on the flip side for episode 3.